Hi, I'm Vance Brabham. I'm an underwriting counsel with Chicago Title in South Carolina, and this is Title Tips in 2. I'm coming to you from Columbia, where the fountain in Five Points has dyed green in advance of the state's largest St. Patrick's Day celebration, which returns this year after a 2-year hiatus. The headlining musical act this year is Blues Traveler. So grab yourself a green beer and pull up a seat. I won't give you any runaround as we discuss the latest tax sale case from the Court of Appeals. The case is Scott v. McCallister out of Williamsburg County, and much like the buffet at Brown's Barbecue outside of King Street, the surprisingly lengthy opinion has plenty of sides, but the meat of the case is pretty simple. It's a little tangy, just like old St. Patrick preached that barbecue should be to the ancient Gaels. The facts: Scott entered into an oral agreement to purchase property from her uncle McCallister. There's some dispute in the case as to the terms of the contract, and even whether it was still valid, but that's not really important to the outcome. After suffering from a stroke, McCallister moved to Columbia. The notice address on file at the county tax office was changed to reflect the move. Shortly afterwards, 2011 taxes were not paid. The county levied against the property, and ultimately the property sold to a third party at the December 2012 tax auction. Scott, who still lived at the property and had occasionally paid the taxes in lieu of payments to her uncle, was apparently unaware of the sale until after the redemption period had run and the tax deed was issued. Her first notice of the sale was the appearance of the surveyor on the property who'd been hired by the tax sale purchaser. Scott filed suit seeking to void the tax sale on the ground that the tax notices were sent to the Columbia address rather than to the property address, and also based on there having been no notice posted at the property, which the county actually disputed. The trial court granted summary judgment in favor of the county. The Court of Appeals affirmed, noting that the county sent the required mailings to the address provided by the taxpayer, and that the public record contained no indication of Scott's alleged interest in the property. The court critically found that Scott did not have standing to contest the county's notice because the county only owed a special duty to the taxpayer and interested parties of record. Given that both Scott and McCallister testified that notice was never posted on the property, as is required by statute when certified mail is returned, summary judgment, I think, might have been reversed had McCallister been the plaintiff, or if Scott had a recorded property interest, or if the court had come down differently on Scott's standing. The full case is an interesting read with a few more interesting details, and is a very good reminder of why insuring over tax deeds is problematic and can lead to claims. If you find a tax deed in your chain of title, feel free to contact one of our underwriters, and we'll be happy to discuss it with you. Otherwise, if you can't come to Columbia to take in the festival, the folks here at Chicago Title hope that your St. Patty's Day is grand.